Good afternoon and welcome to today's webinar, Litigation Against Opioid Manufacturers, Lessons from the Tobacco Wars, brought to you by the Network for Public Health Law and the American Society of Law, Medicine, and Ethics. I'm Charles Strong, the Digital Marketing Coordinator at the Network for Public Health Law's National Office, and I'll be your host for today's webinar. Please feel free to submit questions at any time during this webinar by using the Q&A tab on the right-hand side of your screen. All you need to do is click on that tab, select all panelists from the Ask drop-down menu, and submit your question. Your moderator for today's webinar is Hector Hernandez-Delgado. Hector is a staff attorney at the National Health Law Program, and his work focuses on substance use disorders and legal and policy efforts to address the opioid epidemic. He also works on general health care reform issues both at the federal level and in the state of California. Hector will be leading us through the rest of today's webinar, so Hector, over to you.
Corey is the Deputy Director at the Network for Public Health Law's Southeastern region and a staff attorney at the National Health Law Program. Before joining NHELP, Corey served as an employment rights attorney at Equality Advocates Pennsylvania, where he represented lesbian, gay, bisexual, and transgender individuals before administrative commissions and in state and federal courts. Prior to joining Equality Advocates, Corey oversaw a street-based legal clinic sited at Philadelphia's Syringe Exchange Program, and in both of these positions, he provided direct legal representation as well as education, outreach, and strategic advocacy. Corey has also worked for the North Carolina Institute of Medicine, the University of Pennsylvania, and the Drug Control and Access to Medicines Consortium in both research and management capacities. We'll then hear from Laney Rusco. Laney is an associate professor of health policy and management at the Johns Hopkins Bloomberg School of Public Health and co-director of the Johns Hopkins Center for Law and the Public Health. She is jointly appointed in the school's Department of Health, Behavior, and Society and the School of Medicine's Department of Emergency and Emergency Medicine. Dr. Rusco is a core faculty of the Johns Hopkins Center for Injury Research and Policy, the Johns Hopkins Center for Mental Health and Addiction Policy Research, and the school's Office of Public Health Practice and Training. She uses legal quantitative and qualitative research methods to conduct policy analysis and evaluation in areas including emergency preparedness and state and local public health legal innovation. And last but not least, we'll hear from Derek Carr. Derek is a staff attorney at Change Lab Solutions, where he focuses primarily on tobacco control, chronic disease prevention, and health equity. However, Derek is joining us today in his capacity as a fellow with the Network for Public Health Law. As a network fellow, Derek researches and publishes on the opioid epidemic and legal interventions to reduce drug-related harm, including being a lead author of the paper Reducing Harm Through Litigation Against Opioid Manufacturers, Lessons from the Tobacco Wars. Derek also worked on Medicaid advocacy issues as a legal intern at the National Health Law Program's North Carolina office. And with that, I'll pass it over to Corey for our first presentation. Corey?
Great. Thank you, Hector. So I'm just going to give a brief introduction to the other two panelists, and then I'm going to follow up again at the end with some kind of parting thoughts before we go to the Q&A. And as Hector said, if you have questions for any of the panelists, please feel free to just type them in as we're talking, and we'll get to them at the end. All right, so I want to briefly set us up. Many of you on the phone call are probably aware of the severity of the epidemic. But briefly, there were around 44,000 Americans who died from opioid overdose in the last 12-month period for which we have data, and those are confirmed opioid deaths. That's surely an undercount. We just don't know how much worse it actually is. But overdose is now the leading cause of death for Americans under the age of 50, which is is really just extraordinary when you think about it. More Americans are dying from overdose than are dying from car crashes, more from gun homicide and suicide combined, more than die from HIV/AIDS. At the height of the epidemic, before HART came online, so it's truly a public health emergency, and unfortunately, it seems to be getting worse. So what is the role of opioid pain relievers? And so opioid pain relievers accounted for about 40%, or were involved in about 40% of all opioid-related overdose deaths in 2016. Unfortunately, so that number is going down, that percentage is going down a little bit really every month. Unfortunately, that is mainly due to the fact that the denominator is increasing. The number of overdose deaths is decreasing, where the number of opioid pain reliever related overdose deaths is decreasing a little bit, or remaining stable. It's actually kind of still a little hard to tell. Here is, you can see this shift in the causes of opioid overdose fatalities. So this takes you from 2000 to 2016, which is the latest aggregate data that we have. You can see this shift. The purple line here is natural and semi-synthetic opioids. That is largely, but not entirely, opioid pain relievers, and there's a little bit of flex around that one because it's sometimes hard to tell how to classify the illicitly manufactured fentanyl, but you're seeing that in this other synthetic opioids line here, which has just really taken off over the past 5 years. But of course, at the end of the day, the really important line here is the green one, which is deaths from any opioid, which are just still increasing at a really frightening rate. The epidemic is unevenly distributed. As with most health burdens, some folks are affected more than others. With the opioid epidemic, we see that it's mirroring both sort of chronic health conditions in general, as well as to some extent incidents of chronic addiction-related problems. So we've got really high burden, particularly in rural areas through Appalachia and in the rural Southwest. It's also important to note that pain is unevenly distributed. The pain is a serious problem in the United States and worldwide, and it is unevenly distributed. So women, on average, experience more pain than men. That is not because women complain about pain more. It seems to be, physiological in nature. Has a lot to do with the fact that women bear children. Lower income Americans also report higher levels of pain, more likely to be injured on the job, more likely to work the types of jobs that involve a lot of physical labor, also less likely to be insured and have access to quality health care. For similar reasons, Hispanic, Latino, and African Americans are more likely to be injured on the job. And, there are a number of studies that have shown that they are less likely to get quality care, including to be prescribed opioid pain relievers. There's a discussion about whether or not, whether on net that's good or bad, but it is a fact. But of course, pain, I want to emphasize this, that pain is a serious and important concern, particularly chronic pain affects a lot of people. It can be debilitating, not only physically, but also affects your ability to work, your mental health status. So, pain is really important. The problem is that opioids just do not do a great job for a lot of pain for a lot of people. Opioids are very helpful, particularly for some people in some situations, some post-surgical pain, cancer pain, end-stage AIDS, palliative care. Opioids are extremely helpful for some people with some types of those conditions. And the problem is that there is actually very little evidence for the benefits of opioids for a lot of the conditions for which they are prescribed. In fact, there's either no good evidence or, it seems like every day there's more emerging evidence that opioids are in fact no better than non-opioid treatment for a lot of conditions for which they are prescribed, and of course have these risks associated with them. It's always hard to draw, you want to be very careful drawing broad conclusions from population level data. But the fact is that we've seen about a 300% increase in OPR prescriptions from 2000 to 2014 or so. So we have 3 times as many opioid pain relievers being prescribed, but no population level decrease in pain that we can see. Now, it's actually kind of difficult to measure pain for a number of reasons, but you might think that if these are actually powerful painkillers and we're dramatically increasing their prescription, that we should see some evidence in aggregate data that pain burden is going down. And there is just no signal there. It seems to be the case that pain continues to increase even as opioid pain reliever prescriptions continue to increase. Now, none of which is to say that opioid pain relievers don't have a role to play. They certainly do, but it definitely suggests, at least to me, that the optimum rate at which they should be prescribed is somewhere far below where we currently are. So here is just one of those, in my mind, one of those pictures that's worth 1,000 words. You can see at the bottom opioid-related deaths, and at the top line is sales of opioid pain relievers. So it's really hard to believe that there's no correlation here. So why is law important, or what is the role of law? There has been some federal legislative action. Some federal agencies, including the CDC and SAMHSA, have been really doing some solid work to try to address the epidemic. But at least it seems to me that the federal government has not been addressing this the way that they would if this was some other epidemic. If we had a pandemic influenza or a swine flu or something that was killing 60,000 Americans a year, I think that we would see a much more robust response. So it means that states and localities are really stepping in and trying to fill that void. They're doing a lot of things on the legislative realm, a lot of things on the policy realm, and we have a lot of information about that on our website, and I invite you to look at it. But today we're going to talk about non-legislative and policy actions, particularly in the form of lawsuits, of tort suits against not only opioid manufacturers, but also distributors and a bunch of other folks involved in the opioid supply chain. So with that setup, I'm going to turn it over to Laney Rusco, who is going to lead us off.
Great. Thanks so much, Corey. And before I begin, I want to also thank Charles, our host, Hector, our moderator, and Corey and Derek, my 2 co-panelists today. So you can see from this first slide that I'm going to be providing a little bit of context for what I think of as the main event of this webinar, which will be Derek's presentation about current litigation against opioid manufacturers. But Corey, Derek, and I thought that it's helpful to provide context for that by thinking about litigation against the tobacco industry. One more thing as a little bit of setup for these next few slides. Of course, we all know that there are major differences between tobacco and opioids on so many levels. First of all, tobacco products are, for the most part, legal, have no known health benefits, and have these days a regulatory structure, primarily at the federal, but also, depending on how you frame it, at the state and even local levels. On the other hand, opioids may or may not be legal. They have, the ones that are legal have a complex regulatory structure through the FDA, and so I raise those points just to remind us and to, of course, make all of you aware. We understand that these are very different products. However, there are lessons to be learned by looking at several decades back in litigation against the tobacco industry and then thinking through what we're seeing today relative to opioid manufacturers. So when folks talk about the history of tobacco litigation in the United States, they tend to refer to it in waves. And the first wave of that litigation actually lasted a pretty long time. You can see on this slide, it was about a 40-year span from the 1950s to the 1990s. And what we saw during that time were primarily individual smokers, often folks who had smoked cigarettes from their teen years to the end of their life. And so they were bringing lawsuits as individuals against tobacco manufacturers. And what they would argue was that the tobacco companies had either negligently failed to tell them, the consumer, about the harmful nature of tobacco products, or they would argue that tobacco manufacturers should be held strictly liable for marketing what is clearly a dangerous product. Now, during that 40-year period, over 800 of these types of lawsuits were filed, and none of them were successful for the plaintiffs. And there are many reasons for that. Some of the more common strategies that were used by the tobacco industry during this period were to present arguments against any science that might link tobacco use to any negative health outcomes. They would raise questions about individuals' lifestyles and challenge how anyone could be sure that it was smoking rather than some other aspect of an individual's lifestyle that had led to the health condition that they currently faced. And the tobacco companies also obviously are much more well-financed than any given individual, and so they were able to prolong these cases until individuals, or after their deaths, their families, simply ran out of money or time or the desire to continue pursuing litigation. So that's wave one. And then, sort of in the 1980s into the 1990s, after this relatively demoralizing first wave of litigation against the tobacco industry, plaintiffs' attorneys and public health advocates, some of whom I suspect may be listening right now, began to regroup and to develop new legal theories that would hopefully lead to success, lead to decisions in favor of plaintiffs. Now, what happened during this second wave of litigation, the very short story is that the tobacco companies, by and large, did not pay out financial judgments against them. But there was one very important case that I want to highlight now that changed the nature of litigation moving forward. And that case is called Cipollone versus Liggett. You can see on this slide, it's a case that was decided in 1992 by the U.S. Supreme Court. And it's actually a very long, complex decision, so I'm going to do my best here to shorthand it for you and to bring up the points that are most relevant for today's webinar. So this is a lawsuit that was originally brought by Rose Cipollone. She was a lifetime smoker. She had started smoking Chesterfields as a teenager, and she smoked them until her death in her mid-60s from lung cancer. She initiated this lawsuit and ultimately was carried on by her husband, Antonio, after her death. And the primary legal argument she was making, which ultimately was not successful, concerned using state law to try to bring a challenge to the health warnings that were on cigarette packages. And what she was arguing was that she wasn't she wasn't thoroughly warned about the dangers of this product that she had used for so many years. And you can see on this slide there's one bullet that's in red and two that are in green. The red is to try to distill this long, complex opinion down to the piece that was not favorable for plaintiffs moving forward. And that piece of the opinion says that mandated health warnings, and these are mandated by federal law, on cigarette packages preempt or prevent most litigation that's based on claims about failure to warn. So basically the type of claim that Rose Cipollone attempted to make under state law was found to be preempted by federal law. But, and this is a very important but, and these are the two bullets in green at the bottom of the slide, the Supreme Court also mentioned that federal law does not prohibit lawsuits that are based on tobacco companies' efforts to mislead the public. So the Supreme Court gave potential plaintiffs a little bit of a roadmap for how they might move forward with future litigation, even though it couldn't benefit Rose Cipollone in this case. The other important thing that came out of this Supreme Court decision is that internal tobacco industry documents became publicly available. And I'm sure for anyone who's been working in public health, even if you haven't read them yourself, you're probably familiar with the fact that at this point there are thousands upon thousands of once secret internal tobacco industry documents that are now publicly available. They're housed in several repositories. I believe the largest one is at UCSF. This case is viewed by many as the beginning of that release of documents into the public domain. So that's the second wave of litigation against the tobacco industry. And then that moved directly into this third wave of litigation where the 1992 Cipollone case, which kind of gave a hint at this way to move forward with litigation that concerned tobacco companies' attempts to mislead the public, that piece of the decision, coupled with this ongoing release of previously internal tobacco industry documents, led to litigation that explicitly focused on tobacco industry misconduct. And that in many ways characterized this third wave of tobacco-related litigation. And you can see in the middle of the slide that in the mid-1990s, using this updated legal theory, there were individual and some class action lawsuits that yielded verdicts or, in some cases, settlements that favored plaintiffs. And so this is where, from a litigation perspective, we begin to see the tide turn a bit. And something else important happened while this third wave of litigation was occurring in the mid-1990s, and that is the role that state attorneys general began to play. So I'm sure this is familiar to many of you, but to make sure we're all on the same page, within each of the 50 states, there's an attorney general who is the highest-ranking legal officer in the state. And in May of 1994, Michael Moore, who was the Attorney General in the state of Mississippi, filed a lawsuit against the tobacco industry on behalf of his state, and he used a different type of legal theory that turned out to be a real game changer. In the lawsuit, he detailed the tobacco industry's efforts to mislead the public, and perhaps more importantly, he argued that tobacco companies should be responsible for Medicaid and other state-based health care costs that are incurred due to tobacco-related disease. And for the states, these costs are, at the time this lawsuit was filed, in the millions every year. And this is an innovative argument So much so that it received attention from state attorneys general in other states. And you can see here that within about a year, similar lawsuits to recoup Medicaid and other state-based healthcare costs related to tobacco use were filed by the attorneys general from Minnesota, from West Virginia, from Florida, and Massachusetts. And ultimately, 43 states filed similar lawsuits against the tobacco industry. And so there was this wave of attorney general-led litigation coming out of the states using similar arguments about reimbursement of healthcare costs borne by the state due to tobacco-related disease. And that wave of AG-initiated lawsuits, with this kind of ongoing drip, drip, drip of public release of previously internal tobacco company documents, led to willingness among the tobacco companies to talk about a settlement. And ultimately, that settlement is known as the MSA, the Master Settlement Agreement. But before we get there, I want to just provide a little bit of context for what led up to 1998. So in the mid-1990s, in 1996, 5 of the suing states, so these are the suing states, meaning the AG-initiated litigation, settled with one tobacco company, with Liggett. And in the next 2 years, 4 additional states settled, but that left most of the states that had pending litigation against the tobacco industry, along with Washington, D.C., and that grouping that I just mentioned became known as the settling states, and they are the ones who ultimately entered the Master Settlement Agreement, the MSA, with the 4 largest tobacco companies. And the MSA remains the largest civil settlement in U.S. history. This group, the settling states, receive approximately $200 billion over 25 years. So that was in 1998, so we're still in the 25-year window, with the potential for additional payments in perpetuity based on a formula that involves several considerations, including annual volume of cigarette sales. Now, there are some additional features of the MSA that I want to briefly highlight, and then I want to make one important point about what it means for future litigation. So while most people, when they think about the MSA, they focus on that $200 billion number, that payout from the tobacco industry to the settling states, the MSA did several other important things. It provided funds for a national foundation, which became Legacy, the American Legacy Foundation, that had several advertising campaigns to reduce tobacco-related disease and tobacco use among young people. The most high-profile has been the Truth Initiative. Under the MSA, additional thousands of internal tobacco industry documents were publicly released. The MSA put restrictions on marketing and advertising practices for tobacco. Obviously, these products can still be advertised, but the MSA put restrictions on what was previously allowed. Industry groups, industry front organizations for tobacco were disbanded, but in exchange for the settlement, tobacco companies were released from being held liable for current and future healthcare cost reimbursement claims, meaning that the type of litigation that they were facing from the state AGs, they could no longer be subject to that type of litigation again from the settling states. So the settling states had to drop all claims against the tobacco industry for Medicaid and other state-related healthcare cost reimbursement for tobacco use. Now, the last point that I want to make, and it's in green at the bottom of this slide, is that the MSA, while it did affect future lawsuits from the states related to healthcare cost reimbursement, it did not affect lawsuits that are brought by individuals or by entities other than that group that I explained is known as the settling states. And so with that history and to provide a bit of context, I'm now going to pass to Derek, who will be the main event for this webinar. Oh, and I forgot my last slide is a false promise that says I'll take questions, but I actually will not be doing that until the end of the webinar. So thank you, and now I'm going to pass to Derek.
Thank you, Laney. I don't know about main event, but I will do my best, and thank you to Corey, Hector, and Charles as well. As Hector mentioned, I'm a staff attorney at Change Lab Solutions, but I am here today wearing my hat as a fellow with the Network for Public Health Law. And so before getting started, I just want to clarify that all the views that I'm expressing during this presentation are mine alone and shouldn't be attributed to Change Lab Solutions or any other organization with whom I'm affiliated. So now that Corey and Laney have set the stage by providing some context on the opioid epidemic broadly and the history of litigation about the tobacco industry, I want to jump now into talking about how litigation against prescription opioid manufacturers have played out thus far and discuss what might come next. As you can see, government-led litigation against the prescription opioid industry has gone on for nearly 2 decades, which is a really long time, but it's still only a fraction of how long it took for the tobacco lawsuits to evolve. If you think back to Laney's slide, that the tobacco lawsuits were going on since the 1950s and didn't eventually result in the MSA until the late 90s. And while there were some individual people that brought lawsuits against opioid manufacturers and distributors and pharmacies or doctors before this, the first major state lawsuit against an opioid manufacturer came in 2001 when West Virginia sued Purdue Pharma over alleged illegal marketing of OxyContin. That case settled in 2004 for about $10 million. And then shortly thereafter, 26 states and the District of Columbia filed a class action lawsuit also against Purdue that made many of the same allegations as West Virginia did, including that Purdue marketed OxyContin for off-label use and failed to disclose the diversion and addiction risks presented by the drug. And Purdue settled that lawsuit in 2007 for a relatively small sum, but a concurrent federal criminal investigation into the company resulted in 3 company executives and the company itself pleading guilty to illegally marketing OxyContin. Over the next several years, a number of states sued various opioid manufacturers, and some other companies like Cephalon were also subject to criminal charges. And then finally, in late 2015, the Mississippi Attorney General's office, the same office, if you recall, that sparked widespread state litigation against the tobacco industry, filed a new kind of lawsuit that targeted the prescription opioid industry as a whole rather than attacking individual manufacturers. 4 more states filed similar lawsuits in 2017, and if we fast forward to the present time, more than 19 states and hundreds of local jurisdictions have sued opioid manufacturers and distributors, and I believe I saw that 1 more state was added to that list earlier today as well. But to understand what might come next, it's important to look at some of the details of these cases leading up to this point. So I first want to highlight the federal criminal charges against Purdue for 2 reasons. The first is that it was one of the only cases thus far that resulted in significant financial penalties. Even with the class action backed by 26 states and D.C., that case settled for less than $20 million, which is really pennies compared to the billions Purdue made annually from OxyContin sales. And unlike in previous settlements, Purdue actually admitted to engaging in misleading and illegal conduct in order to increase the sale and use of OxyContin. And these quotes on the slide come directly from Purdue's guilty plea, and I think really speak for themselves in how Purdue deceptively marketed OxyContin as a quote-unquote safer opioid. If we take a little bit of a step back, we can see that just as with the tobacco litigation, lawsuits against opioid manufacturers have fallen into a couple different waves, and each wave has its own unique characteristics. The first wave that started with West Virginia's 2001 lawsuit against Purdue and continued until the recent flurry of lawsuits over the past few years was characterized by a focus on individual prescription opioid manufacturers and company executives. So each lawsuit targeted Purdue or Cephalon or Insys. They were fragmented efforts intended to address very specific alleged misconduct. And these first-wave lawsuits settled for relatively small sums of money, from INSA's $500,000 settlement with Massachusetts to Purdue's less than $20 million settlement with 26 states. And these small sums were clearly an insufficient incentive for these companies to change their business and marketing practices, representing only a tiny fraction of the $10 billion annual prescription opioid industry. However, as public scrutiny of industry practices increased, several states and local governments decided to take action to hold OPR manufacturers collectively accountable for their role in fueling the opioid epidemic. These lawsuits named all of the major manufacturers as defendant, or at least most of them, Purdue, Cephalon, Teva, Janssen, Johnson & Johnson, as well as others, and many included opioid distributors and even some pharmacies as well. The second wave of opioid lawsuits has also been characterized by greater coordination, including a bipartisan investigation by 41 state attorney generals. This is another really big parallel between the opioid litigation and the tobacco litigation, where with tobacco, as Laney mentioned, the involvement of the state attorney generals is really what was kind of a tipping point. And finally, the second wave lawsuits seek significantly greater financial concessions that are likely to range in the billions of dollars, not the low millions. So what are the claims against opioid manufacturers made in these lawsuits? At their core, just like with the tobacco lawsuits, these suits are attempting to recover government costs that they've incurred in responding to the opioid epidemic, including for things like health care and law enforcement. And state and local governments are arguing that the opioid industry, rather than taxpayers, should be responsible for those costs. To those ends, the lawsuits are pursuing a number of different legal claims, and I'll just give a really high-level review so I don't bore the non-lawyers on the webinar. But there are some common themes that have emerged. For example, most of the lawsuits argue that the opioid manufacturers engaged in Medicaid fraud because state Medicaid programs paid for prescription opioids based on the manufacturer's misrepresentations about their potential benefits and harms posed by the products. Similarly, states argue that those misrepresentations or similar misrepresentations constitute unfair and deceptive trade practices that violate laws designed to protect consumers. Public nuisance claims argue that the manufacturer's conduct negatively affected the health and safety of the community as a whole, rather than focusing on any harm to a specific individual or even harm to the government itself. So you're really talking about population harm and widespread harm. And then finally, racketeering claims allege that the prescription opioid manufacturers are engaged in carrying out an ongoing criminal enterprise. And this was also something that we saw in the tobacco context, where the federal government sued Philip Morris and several other tobacco manufacturers under the RICO statute that was designed to go after mafia bosses, but has been used to go after organized crime and criminal misconduct by corporations as well. And some of you have probably seen the corrective statements that litigation has eventually required the tobacco industry to make. So in making these claims against opioid manufacturers, the state's legal complaints detail how the opioid or prescription opioid industry allegedly used many of the same practices used by the tobacco industry to systematically increase the prescription and use of opioid pain relievers. So these include things like paying front groups, physicians, and key opinion leaders to make promotional activities appear independent, avoiding regulatory restrictions such as off-label marketing by using unbranded marketing campaigns, that is, marketing campaigns that just talked about opioids generally as opposed to their specific product, disseminating misleading direct-to-consumer advertising, and really perhaps the biggest parallel to tobacco being facilitating the creation and dissemination of scientifically suspect research guidelines that promoted increased opioid use while misrepresenting the risks and benefits of those products and alternative treatments. And that reflects kind of the tobacco industry's efforts to promote research that said that there weren't any links between smoking and health harms, or to suppress research that established those harms, which they knew very early on. And then finally, opioid manufacturers had very expansive efforts to target practitioners in order to foster new high-volume prescribers. So given these parallels, the comparisons between tobacco and opioids lawsuits are understandable, both the parallels in the types of legal claims being made and the alleged misconduct that the companies engaged in. But there are some key differences that may negatively affect the lawsuits against opioid manufacturers. For one, federal regulation of tobacco products was pretty limited at the time of the tobacco lawsuits leading to the Master Settlement Agreement. And this limited regulation meant that the tobacco industry could introduce, market, and sell tobacco products without much federal oversight, and that really allowed state lawsuits against the industry to proceed without a complicated interplay between state and federal law. And these 3 bullet points about cigarette regulation, that's not a list of examples. That's pretty much the full extent of federal regulation of cigarettes and tobacco products at that time, with perhaps the exception of federal tobacco taxes. But the exact opposite is true when we're talking about prescription opioids. Federal laws like the Food, Drug, and Cosmetic Act regulate nearly every aspect of the prescription drug marketing prescription drug market, from approving medications for specific distribution and sale to post-market surveillance and enforcement. And the Controlled Substances Act subjects certain drugs, such as opioids, even stricter regulation, including requiring prescribers to have a separate license from the Drug Enforcement Agency in order to prescribe controlled substances like opioids. Now, these differences won't necessarily determine the outcome of the opioid litigation. States maintain pretty broad authority to supplement federal regulation of prescription drugs through things like consumer protection laws. And a drug's FDA approval doesn't provide its manufacturers with blanket protection from financial or criminal liability under state law. But nevertheless, the vast federal regulatory landscape for opioid pain relievers does provide their manufacturers opportunities to contest and delay the lawsuits that weren't available in the tobacco context. One example of this is opioid manufacturers have invoked this arcane legal doctrine known as primary jurisdiction in order to argue that the court should hold off on proceedings regarding these lawsuits until the FDA completes a review of the issues presented by them. And this is an argument that's really only available to industries that are subject to pretty expansive federal regulation and where federal law delegates authority to an expert body like the Food and Drug Administration. And courts may be receptive to these arguments considering the complexities of the cases, and that might give opioid manufacturers some breathing room. A judge here in California stayed a case brought by some local jurisdictions here in California on primary jurisdiction grounds. The opioid manufacturers asked the Ohio court to do the same in the Ohio state litigation. And it's not clear how that's going to play out with the litigation moving forward. So given all of this, the history of opioid lawsuits to date, the legal claims and alleged misconduct, and the legal and regulatory environment in which it all takes place, where do things stand? More than 300 of opioid lawsuits brought by state and local governments have been consolidated through a procedure known as multi-district litigation. And multi-district litigation brings together a lot of federal cases that are making similar claims against the same defendants, and it's intended to improve the efficiency of processes that lead up to a potential trial, like collecting evidence and interviewing the opposing parties through things like depositions. The United States Department of Justice recently announced that it will file a statement of interest in asserting that the U.S. government is entitled to part of any financial payments from the opioid industry. And perhaps most importantly, the parties are actively engaged in settlement discussions. I say perhaps most importantly, because a master or global opioid settlement seems really like it's inevitable at this point. The parties to the case have expressed a desire to settle. The judge overseeing the multi-district litigation ordered the parties to prepare for settlement discussions. And honestly, a settlement might benefit all of the parties involved. Opioid manufacturers would get clarity about certain types of potential liability, states get needed funding, and state attorney generals get a legal and political victory against a highly unpopular industry. So the real question is not whether a settlement will happen, it's almost certainly going to, but rather whether such a settlement is actually going to help reduce opioid-related harm. And the Tobacco Master Settlement Agreement experience suggests that such an agreement likely will not be the most effective solution for reducing opioid-related morbidity and mortality. To be fair, the Tobacco Master Settlement Agreement accomplished several important objectives, some of which might have been difficult or even impossible to achieve through regulation alone. So if you think back to Laney's explaining the advertising restrictions that were put on tobacco companies, those types of restrictions wouldn't be allowed under the First Amendment, but since it was a private agreement, they were able to do so. And as Laney mentioned, the MSA also provided the initial funding for the American Legacy Foundation, now the Truth Initiative, which oversaw one of the most successful public health and social norm change campaigns in recent history. And they continue to play a really central role in the fight to end the tobacco epidemic. Tobacco companies also increased the cost of cigarettes to offset the billions of dollars they now owe to states. And some states and local governments did take advantage of the opportunity presented to use the money from the settlement to make robust investments in tobacco control and public health. But the tobacco industry, even though they were subject to some marketing restrictions, like a ban on outdoor advertising, they actually increased the amount of marketing expenditures over the years. They just shifted that money into different avenues left unrestricted by the agreement, like point-of-sale advertising and providing discounts on tobacco products. The Master Settlement Agreement's effect on reducing smoking rates, its ostensible public health goal, is also a little unclear. Smoking rates certainly did decline following the MSA, primarily due to the increased cigarette prices, which we know are one of, if not the most effective way to reduce tobacco use. But these declines began before the agreement and were likely influenced by contemporaneous tobacco prevention and control efforts. So it's not entirely clear what was the result of the MSA and what would have happened anyways, and where to draw that line. But perhaps most worryingly, the MSA calculated payments based on domestic cigarette sales, which really provided a perverse incentive for states to protect cigarette sales. In one instance, attorney generals intervened in a case from Philip Morris that had the potential to bankrupt the company, at least in part to protect the master settlement payments and to ensure that they would keep on going. The vast majority of the tobacco industry payments never benefited the public health in any way. They were diverted for other uses. And by its very design, the agreement ensured the continued existence and profitability of an industry dedicated to the sale of a product known to kill nearly 500,000 people in the United States every year. And to quote James Tierney, a former Maine Attorney General who was a key strategist in the state tobacco litigation, he recently stated in an interview about the opioid litigation that I helped coordinate the tobacco lawsuits of the 1990s, which ended with a giant settlement deal that would have cost cigarette makers more than $200 billion. But much of that money was wasted, and countless people have died as a result. Governors and state legislatures used them to pay for roads, lower taxes, or to meet budget shortfalls. That kind of failed short-term thinking can't be repeated. And we don't even have to look to the tobacco lawsuits, to be honest, or the Master Settlement Agreement for cautionary tales. Prior opioid-related settlements raised similar concerns. We talked about the West Virginia litigation a little bit earlier, and West Virginia spent much of its settlement dollars on a new police gym and remodeling their police academy, which are perhaps worthy investments. You know, we want to support law enforcement, but certainly nothing that would help the tens of thousands of West Virginians that were experiencing harm as a result of opioids, whether that was directly or indirectly through friends and family. And the settlements to this point have shown that they may not be sufficient to fundamentally alter industry behavior. Even after the $600 million in criminal fines paid by Purdue, the company continued to engage in allegedly misleading and arguably illegal practices. And there was also a recent CNN report that kind of highlights this fact that opioid manufacturers, including Purdue, paid doctors thousands of dollars to prescribe their drugs. And to no one's surprise, the doctors receiving the most money prescribed the greatest number of opioids. And so it's clear that to date, these lawsuits have not had their intended effect, if indeed the intended effect is to reduce opioid-related harm as opposed to simply raising money. So what's next? perhaps the scale of the current wave of litigation will change the calculus of the opioid industry. Purdue did recently pledge to stop marketing OxyContin to doctors, which is certainly a step in the right direction, albeit 20 years too late. But as the federal judge overseeing the opioid multi-district litigation recently observed, more is clearly needed, and money alone is not going to solve the crisis. And so we really need to think about what are the most effective solutions, what is going to have the biggest impact, and how do we structure the lawsuits and any potential settlements to really maximize those public health benefits. And with that, I will turn things back over to Corey to talk a little bit about what that might actually look like.
Great. Thank you, Derek. That was fantastic. And thank you, Laney, as well. So I want to bring this back a little bit. Before I do that, I would encourage everyone, there's a Q&A tab on the right-hand side of your screen. Now would be a great time to throw your questions in there, and we will answer them. I also want to plug, if you found this interesting and you would like to read more about it, Laney, Derek, and I recently published an article on this topic that goes into much more detail about the things that we've discussed today. It's in the journal Public Health Reports. If you don't have access to that, drop one of us an email or a chat, and I think we'd be happy to send it to you. So I just wanted to briefly kind of follow up on where Derek ended. So what is the context of the litigation in terms of what states are doing, could be doing, should be doing? Well, as all of you know, states are doing a number of things to try to address the epidemic. Some of these are being moved by public health actors. These are things like, I would say, increased access to naloxone is a good example. Some really have more of a criminal justice bent. I would say things like increased penalties for fentanyl distribution, the increased emphasis on things like charging drug-induced homicide go in this category. Some are simply looking for money. There are a number of states who have proposed, for example, taxes on opioids, on opioid prescriptions. These are just driven by a desire, honestly, to do something. Legislators are hearing very clearly from their constituents that this is a serious problem, want to know what their legislators are doing. The legislators are looking to the federal government and seeing that there's not much happening there. And they're just, I don't mean this pejoratively necessarily, but they're thrashing around looking for something to do. They see things, and they're doing them. Some of those things are probably good. Some of those things are probably bad. A lot of them, we just don't know yet. The jury is still out on a lot of these things. So, this is classic public health policymaking. It's complicated, but it's important to get it right, or at least to try to get it right. And every time I think about the opioids, opioid law, policy, and litigation, I'm just reminded of this scene from Carol's Alice in Wonderland, where Alice meets the Cheshire Cat. And she asks him, will you tell me, please, which way I ought to go from here? And the cat says, that depends a good deal on where you want to get to. And Alice says, I don't much care where, so long as I get somewhere. And the cat says, well, it doesn't matter which way to go, you're sure to get somewhere if you walk long enough. And, when I think about the laws and policies and litigation, it almost seems to me like we are in Wonderland. And sometimes it doesn't seem like there is much thought given to where do we want to go? What is our ultimate aim here? And I think that, that's kind of true of the litigation as well. So what are the goals of litigation? The main driver, as Derek said, seems to be to get money, to reimburse states for the money that they have spent on emergency services, on public expenditures through the Medicaid program, on other sort of public health measures. It's just to recover funds for those services. And to some extent, that is, there are legal reasons for that. And that's not unreasonable. Opioid use disorder is a serious problem. It causes a lot of damage in terms of lost lives and morbidity and mental health problems and destroyed families and all of that. But it also costs a lot of money, both in medical treatment, but also in things like lost productivity, lost work, and that sort of thing. So it's not unreasonable to try to get compensated for the money that states and localities are spending on those things. But you got to keep in mind the opioids manufacturers have a lot less money than the tobacco manufacturers did and do. It's a little hard, but it's reported that the entire U.S. opioid market is around $10 billion a year. Now, $10 billion isn't chump change, but compared to the amount of yearly costs associated with opioid use disorder, which are estimated to be in the tens to hundreds of billions of dollars, depending on how you calculate it, that's a really, really, really big hole to fill. I would say, these lawsuits are they're being led by state attorneys general and to some extent now municipalities, but they're not being driven by public health leaders. And it also seems like with a lot of these, as with a lot of opioid-related law and policy, public health people aren't even really at the table sometimes. Nobody is going to public health leaders and saying, if we could get something, if we could get three things from the opioid manufacturers, what would they be? As far as I can tell, nobody is going to the public health leaders and asking them that. And I think that that's a real missed opportunity because, as Derek said, when you look to the tobacco litigation, the important things that came from that MSA, at least the most important things, isn't the money. The money was largely squandered. I mean, some states have done really good things with that money. It's not a universal truth, but it is largely true. Most of that money did not go to public health initiatives. The really public health benefits from that settlement came from things like restrictions on advertising, came from things like funding the Truth Campaign. And we really should be thinking about those sorts of things as we think about the master settlement agreements. So I've put up here a logic model. If you're a public health person, you are familiar with these types of logic models. And I really think that we in public health law, or lawyers in general, should really adopt this, should adopt these things as well. So when you're thinking about what are we trying to do with this law or this piece of litigation, you should really start on the right-hand side. Like, where do we want to get? And you should be doing that in coordination with public health leaders, asking them, what would, if our goal is really to reduce opioid-related harm, how can we best do that? Some of those leaders are going to say, well, we could use a lot of money, but a lot of them are probably going to say, well, money is nice, but what we really need is X, Y, or Z. So, I just want to, plant this seed that, if you're not at the table, if you're in a state or a municipality that has one of these suits and you're not at the table, nobody has asked you, what, if we're going to settle with these opioid manufacturers, what would you like us to try to get from them? You really should be. You really should be elbowing your way into that table and thinking about that, thinking about what is on the right-hand side of this logic model. Where do we want to get with these things? where do we want to get? So should money be the goal? Well, like I said, money is useful. Money is great. You can buy things with money. You need money to do things. But it's also important to think about, okay, if we get the money, we need to make sure that it is earmarked for things that are going to be useful. We don't want an opioid MSA to go to, fix potholes or to, fill the budget hole that's there because there was a big tax cut that was passed or something like that. And we want to make sure that that money is earmarked for things that either no work or we have a good logic model that says it should work. Things like medication-assisted treatment, increased access to naloxone, syringe access programs, maybe supervised consumption facilities. Things that are going to reduce the health consequences of opioid addiction and opioid misuse. Public health intervention. We also want to, again, plant the seed that a lot, we can't just be thinking, we need to, think broadly. Can't just think about, treatment. Can't just think about, tertiary prevention. Keep in mind, quality child care is overdose prevention. Quality education is overdose prevention. Decarceration is overdose prevention. Basically anything that is going to improve the quality of life of people in your state, particularly in the early years, is going to increase access to necessary healthcare services, is overdose prevention. And we really need to be making that point to the folks who are leading this litigation and the folks who are doing lawmaking in general. So I'm gonna end here, but I want to give you a couple parting thoughts. This is a public health crisis. We need a crisis-appropriate response, and that response really needs to be evidence-based and equity-focused. It needs to be, again, we need to think about what we actually need, what would actually help us address this crisis. And it could be that money is in the middle part of our logic model there, but money should not be on the right-hand side. The goal should not be money. If we need money, that should be a means to an end. We should really have thought through, if we get the money, here's what we're going to do with it, and make sure that we actually do that. And of course, litigation is just one tool in the box. There are lots and lots of other things that we can and should be doing through law, through policy, through regulation. Like I said, we need to ensure that that money is spent well. Think really hard about, okay, one of the nice things about a settlement agreement is that you can potentially get companies to agree to do things that you couldn't get them to do through regulation. And the advertising restrictions are a great example from the tobacco litigation, because of First Amendment issues, you almost surely couldn't have imposed some of those restrictions through law, but we got them through the MSA. What is the corollary in the opioids world? So we really need to be thinking about those things. And like I said, there are lots of things that we can and should be doing right now. We need to make sure that we're doing them contemporaneously with the lawsuit. So I'm going to turn it back to Hector. And again, please post your questions in the Q&A box on the right-hand side of your screen. And Derek, Laney, and I are happy to answer them.
Great. Thanks, Corey, and thank you to all of our presenters for those amazing presentations. So here's the instructions for the Q&A. If you haven't been able to type in your question on the Q&A tab, you can do so now. We already have a couple of questions, and so we'll go ahead and start with those. So the first question is, how will the penalty after litigation be split up between the different opioid manufacturers or opioid companies. If Derek wants to take that question, or Laney or Corey.
Yeah, so I'll chime in, and Laney, please correct me if I'm wrong on any of the details. So the Tobacco Master Settlement Agreement split up costs based on the relative sales levels for each manufacturer. So you have this overall figure that is there, and then maybe adjusted overall based if domestic cigarette sales as a whole go down. But then it also based how they were going to divide those payments based on the relative market share of each of the companies that were a part of the original MSA agreement or that became subsequent participating manufacturers in the agreement, which are essentially just parties that were not involved at the litigation and initial settlement phase, but that signed on and agreed to abide by it at a later date. If that's one way that the opioid litigation can be done. What are the relative market shares between Purdue and Cephalon and Janssen? That it might be a little bit more difficult in this case because there are multiple drugs involved and you have multiple companies making generics of the same medication, so it's a little bit harder to track. But it's probably the most likely solution in my mind, or you could do some sort of equitable distribution among them. And I think that will also be part of what the settlement conversations are going to be. The individual manufacturers are going to come up with what they're willing to accept in terms of cost sharing, and they'll then be up to the states and local governments to decide if they're on board and willing to accept that division of financial responsibility.
Thank you, Derek. So we have another question that you might be able to answer, or Laney or Corey jump in if you have something to add. So the question is, what are the legal issues that pose the biggest concern in multi-district litigation? Is it preemption or the ability to satisfy the elements of any of the state claims, or any other issues that you think poses the biggest concern in multi-district litigation?
Laney, do you want to take it, or do you want me to?
Why don't you start, Derek, and I can jump in.
Yeah, so I think the first part of that answer is to clarify a little bit that the purpose of multi-district litigation is to consolidate the procedures that precede the actual legal trial. So we're talking about things like discovery of finding evidence on and requesting evidence from the various sides, or deposing the executives and employees of the tobacco industry. It's not that the cases will all then be tried, assuming they get to trial, together. Those claims, once those initial processes are done, will then get sent back to their respective state or federal courts where they were filed, especially since many of these claims are being done under state law and not under federal law. In terms of what the biggest issues are going to be if and when those claims go back to the other courts, I think it's really dependent on what specific claims you're talking about, who the actual parties are. If you're talking about intentionally misleading conduct that is proven, the barriers are pretty minimal. As long as you can prove that has happened. The biggest defense there might be what's known as the learned intermediary doctrine, which doesn't exist in all states but does in many states, which essentially just says that because the opioid manufacturers were primarily marketing to doctors, and doctors are these expert people that are making the medical decisions as to whether to prescribe a drug for the patients. And so the drug manufacturers will argue that even if we said something misleading to the doctor has this independent responsibility and knowledge to correct that and to warn the patients about the risks of the drugs. And that is an argument, and it's not necessarily a winning argument. And then with respect to preemption, I think that's a bigger issue when you are talking about failure to warrant claims with regards to generic medications. And the reason for that being is that because under current federal law, generic manufacturers can't unilaterally change the labeling of their products in order to include additional warnings. They have to include whatever warning requirements are on the brand name approved medication. So while the manufacturers of the brand name medications, in this case primarily Purdue Pharma of OxyContin, or incest with Subsys and Cephalon with Actique, those brand name medications, that sense isn't there because they have the ability to go out and add additional warnings about the dangers and potential risk of their products. But for a company like Teva that's just making a generic version of that, they can't do that under federal law. And because of that, there have been courts that have found that failure to warn claims in those instances are preempted by federal law. Yeah, Laney, do you have anything to add there? I mean, I think it's really dependent on what claims you're talking about and who.
Yeah, no, thanks, Derek. That was great. Just as a little footnote, I was just going to say that there will be, if we think about opioid litigation versus tobacco litigation, and Derek, you pretty much touched on this, that you would expect to see some overlap in legal issues, but also very different issues come up because, again, the regulatory scheme for legal opioids is quite different, and certainly quite different from what was happening in the mid-1990s relative to regulation of tobacco products.
Thank you, Laney and Derek. So we have a couple of more questions. Next question is, so who has the obligation to monitor suspicious orders? And who has the information to monitor these orders? Is it manufacturers or distributors? Corey, do you want to take a crack at this one?
Sure. I mean, that's a great question, and there's no good answer to it. I mean, I would say I am not a pharmaceutical regulatory expert, but the system is really designed to kind of trust that all of the actors are acting in good faith. So the DEA has the responsibility of setting what are called quotas every year, so they kind of say how much of a particular drug can be manufactured in the United States. But that is not really based on any sort of an evidence-based process. That is really, for years what they did was just looked at the amount that was sold last year and added something like 25% and set that as the quota for the next year. And that was, just under the assumption that manufacturers knew what they were doing, under the assumption that the prescribers knew what they were doing, that the dispensers knew what they were doing, that everyone in that process is sort of operating in good faith. And unfortunately, I think what we're seeing here is that that system breaks down when one or more of those actors are not operating in good faith. And that's, really, I think this litigation and a lot of the state-level litigation are attempts, a lot of the state-level legislation and regulation are attempts to sort of address that fact that the federal regulatory regime really is just not appropriately designed to deal with these bad actors. And, so states are trying to step in and bridge the gap there. Yeah, so that would be my probably not particularly responsive answer. I think the answer there is that there is no one entity that is responsible for doing that. There are a number of potential places for that to happen, but by and large, it hasn't been, and that's part of what got us to where we are.
Thanks, Corey. So I'm going to open this next question to all of our panelists. So the question is, what has been the input of public health experts, including those with previous tobacco experience, in the Ohio litigation settlement discussions?
So my co-panelists may have better answers here, and Jean, I see you're the one asking this question. I'm guessing that means if you're asking it that you are not involved as a public health expert with the Ohio litigation, although I wish that you were. So just from my own following of this, I have not seen a whole lot of, I've seen a lot of talk about, you know, the role of the judge who has all this, all these consolidated action. I have seen very little in the media about the role of public health experts. I don't know, Corey or Derek, do you guys know more than I do?
No, I mean, there's certainly been a lot of the same litigators that were involved in the tobacco context being involved in the opioid lawsuits.
Yeah.
A lot of the same law firms and former attorney generals, but in terms of public health being at the table and what the settlement might look like, I haven't heard anything to that effect, which probably means that they aren't there.
Yeah, I would echo that as well. I mean, I think that this is a serious gap that we in public health need to rectify, and quickly.
Thank you all. So the next question is, so the tobacco industry only made one product as opposed to drug manufacturers. One argument manufacturers and distributors can make is that opioids are only a small percentage of their sales. So how might that affect the settlement and the amount of money to come from such a settlement?
Yes, I think there are two different answers there. The first being that you know, the amount of money is going to be significantly less just because the amount of money spent on opioids every year is significantly less. You know, we're talking about maybe a little more than $10 billion in annual sales of prescription opioids in the U.S. as opposed to significantly more. I don't have the exact figures off the top of my head, but you know, multitudes more that are spent on tobacco every year. The second part of the answer being, you know, opioids only being a small percentage of their sales, you know, I don't know that necessarily affects things. You know, certainly with companies like Purdue and Insys, almost all of their sales come from opioids. But even if you're talking about a giant like Johnson & Johnson that makes, or Teva that make a huge variety of sales, that just means that their overall, you know, market cap is that much higher, but the amount of money that they're getting from the opioids is the same regardless of whether they sell other drugs or not. And so the payments will likely be based on their revenues from opioids and not on the broader context. Laney, does that sound right to you?
Yeah.
Great.
Yeah.
Great.
Yeah.
You want to add something, Laney?
Oh no, I was just saying I agree with Derek's explanation, but obviously, you know, we're theorizing. None of us can see the future.
Although we might try.
So the next question from the panel, from the Q&A is, local governments participating in the settlement may win some money as a result. So what are the models that can guide how they use these funds to address the opioid crisis?
So happy to take a first stab at this, Laney, and then Corey, if you want to. You know, I think the model that can be pointed to, you know, which comes from the tobacco context is, you know, of all places, Oklahoma. So the Oklahoma Tobacco Settlement Endowment Trust was a constitutional amendment that was put on the ballot by the Oklahoma State Legislature that essentially said we are going to put or the vast majority of the money we're receiving from the master settlement into a separate trust agreement that will be run by a independent government agency, and the interest from those from the money that is in the trust will be used to benefit and improve the community health of Oklahomans. And so it is actually written into the Oklahoma State Constitution that money has to go towards efforts to improve public health. And that doesn't necessarily mean that it is all tobacco control, even that does make a big thing or a big part of Oklahoma's work, but includes, as Corey alluded to in his slides, things like complete streets or healthy food and beverages, because all of those things are going to improve public health, even if not getting at the specific substance or harm that led to the money. But we also know that those social determinants are tightly linked with both tobacco use, opioid use, and substance use writ large. And so if you improve the baseline public health of the population, you are also going to reduce associated opioid use disorder, tobacco use, and addiction to substances more broadly. And so I think that Oklahoma model of really protecting that funds and setting up a regulatory scheme in order to ensure that those funds are being spent in a meaningful way is a powerful model and something that can be replicated if states and local governments are willing to put in the political capital to make it happen.
Great. Thank you, Derek. Excuse me. So we have time for a couple more questions. So the next question is, so what's the best strategy to convince those involved in settlements to make prevention their number one goal? Laney, do you want to start with this question?
Oh, gosh. If I had the answer to that question, Hector, but I will try. So one piece of this is to try to capitalize on the evaluative work that's happening now to show from a prevention perspective what types of policies or programs are effective. And since for those involved in the settlements, presumably they're going to be some type of policymaker. So often seeing that something is cost effective, that can have a lot of sway. We are just at the point of starting to see evaluations of some of the policies and programs that have been put in place to address opioid use disorders. So that's one angle that may be persuasive.
So I think that's right. This is Corey. I think I would take a slightly different angle at this. I would say, it is important for public health practitioners and public health folks and other folks who are affected by the opioid crisis to make our voices heard on this. Again, so at the state level, these lawsuits have been filed by state attorneys general, who are almost always elected officials, and where they are appointed by an elected official, and their incentives may not be 100% aligned with those of public health. Their incentives may be more aligned towards getting a win that they can take back to the voters in their state and say, look, we stuck it to those, to big pharma. So it is really important that folks in public health be making themselves heard and saying, that is not good enough. When you look at the right-hand side of that logic model, just getting in money is not the goal. The goal is to reduce opioid-related harm. So what are you doing, Mr. Attorney General or Governor, to ensure that any funds that come in are being used on evidence-based or, things with a very strong logic model? And we do have some of those at work. Medication-assisted treatment is extremely effective at reducing the harms associated with opioid use disorder, and there is no state in the country that is doing a good enough job of getting people who want care into evidence-based care. So my answer would be we need to make it clear what we want, and what we want is that any settlements have as its goal, as its stated goal, improvements in public health, particularly around addiction and opioid use disorder.
Thank you, Corey and Laney. So the next question is, what is being done to implement the National Academies of Science recommendations from the recent report on pain management and the opioid epidemic?
Corey, Laney?
Pass.
Yeah, is it in the context of, in general, or in the context of the kind of litigation that we've been talking about?
I'm assuming it's in the considering in the context of the litigation that we're talking about.
Yeah, I'm sorry, Hector. I'm just not sure that any of us know the answer to that.
Yeah, I was going to say, in terms of the litigation, I haven't seen any. I certainly haven't seen anything explicit about the National Academy's report. Derek, have you?
No, I'm not as intimately connected with this world as you two are at this point.
Okay. So we have time, I think, for one last question. So the question is, do we know if any of the parties have requested equitable remedies that could directly impact public health in addition to damages? Derek, do you want to take a stab at that?
Yeah, I know that there have been requests for injunctions and things of that nature, and I know there's been some talk about things like advertising and marketing restrictions. I don't know at what stage they're in. There's not really a ton of press on the specifics of the settlement discussions happening right now, which is not atypical for settlement discussions, not to have a lot of specifics about them until it's closer to being done. So the cases are certainly requesting that, as most cases do by default when they're filed. But I don't know if there's been a whole lot of specifics about what that would look like being discussed or considered. Laney, are you aware of anything more specific?
Definitely not at the level. I mean, it's a good question, but I'm definitely not aware of anything as specific as this.
But they definitely should. I will add that. As Corey was mentioning, money is only one small piece of the puzzle, and getting things, equitable remedies like advertising restrictions or other agreements that will actually restrict the harms from the product as opposed to just harms after the fact are really what has the potential to move the needle.
Yeah, and I should also add that that even if parties aren't requesting these things, the ultimate details of a settlement agreement could certainly include them.
Great, thank you both. So with that, we're just about at the top of the hour. So I want to thank our presenters again for their presentations and for their answers to the questions. The presentation will be available on the network's website after we finish the call. And we thank you all for attending the webinar. And with that, I'll pass it to Charles.
Thank you, Hector. Yeah, I just have a few final notes. I want to thank everyone for your participation in today's webinar, and thank you to our panelists for presenting today. I learned a lot, and I know our attendees did as well. So you will be receiving an email that will have a video playback of this webinar, as well as slides when it's available, as well as a link to our brief webinar survey. We really value your thoughts and opinions about today's webinar and what topics you would be interested in for future webinars. So please fill that out and send it back whenever you can. And you'll also be receiving an email from ASLME with information on applying to CLE credits for this webinar. Finally, our co-sponsors for today's event, the network and ASLME, are hosting the 2018 Public Health Law Conference at the beginning of October in Phoenix, Arizona, which will include at least one session dedicated to the opioid epidemic that would be led by one of our presenters from today, Mr. Corey Davis. So please make sure that you register for that conference. It'll be one to remember. And I think that concludes today's webinar. Thank you all for attending, and have a great rest of your day.